If I have old debts, do I have to pay them? Ted is here and we'll discuss it starting right now.
This is Debt Free in 30. Here's your host, Doug Hoyes.
Ted, welcome back. Today is January the 10th, 2022. Is that correct? Am I right so far?
And it's only minus 10 today as opposed to the minus 25 it was yesterday.
The weather is freezing, so people watching this in the future will go, hey, it's the summer. I don't know what the problem is. So I am currently in my basement studio. You are alone in your Guelph office.
Right. We haven't had any staff in the Guelph office for months and months and months due to COVID.
So we are both isolated. We had a number of technical and other difficulties today, which is why we are in different cities. The paid subscribers can watch that to find out what actually happened. So let's get on with the show. The question today, can I avoid old debts? Do I have to pay old debts? Now, you and I, as you'll recall, I'm sure, discussed this 5 years ago in February of 2017, episode number 128. And since then, three things have changed. Number one, there was a court case that kind of either clarified or confused the law. Then the Office of the Superintendent of Bankruptcy updated one of her directives, and then we had the pandemic. So let's start with the basics. In Ontario, we have the Limitations Act. You're familiar with that, right? Mm-hmm. And most provinces and states have similar legislation. Paragraph 4 of the Ontario Limitations Act sets out the basic limitation period. And I'm going to quote it here. I wrote it down. Show prep. Paragraph 4, unless this act provides otherwise, a proceeding shall not be commenced in respect of a claim after the second anniversary of the day on which the claim was discovered. Okay. So what does discovered mean? Well, you go to paragraph 5, claim is discovered when the loss occurs. And if we're talking about a demand obligation, like a loan, it is the first day on which there is a failure to perform the obligation once a demand for the performance is made. So there you go, bunch of legal mumbo jumbo. Ted, translate that into English. What did I just say?
So the short answer is 2 years from the last time you made a payment. What they're really looking for is 2 years since the last time you confirmed the debt existed. But the best way to confirm that you owe money is to make a payment on it.
Yeah. So if I send a letter to my credit card company saying, yes, I know I owe the money. Okay, well, that would be affirming the debt.
Right. So, or if you're on the phone with them and you hear the message at the beginning, this phone call may be recorded for quality and other reasons. This is one of those other reasons.
Yeah. So, and I've talked to lawyers about this, and there are some who say that a phone call doesn't count and some that says it has to be in writing and so on. We're going to take the most conservative view possible and say that if you have affirmed the debt by saying, yes, I know I owe it, then that's when the 2-year clock starts. But you're right, the most obvious way is since you last paid.
Make a payment.
So let's talk about what's new. On March 2nd, 2021, Master Mills, as she then was, in the Superior Court of Justice in Ontario, heard the case of John Trevor Eaton, a bankrupt, who I believe was also deceased. He had borrowed money from a friend, someone he knew, stopped making payments on the loan for a long time, went bankrupt. And the court ruled that in order for a claim to be provable in bankruptcy, it had to be recoverable by the legal process. And since it was so old, couldn't be claimed in the bankruptcy. Interesting. So as a result of that, in December of 2021, the Office of the Superintendent of Bankruptcy released a new directive that says a trustee, when doing the initial assessment, must explain debts that are statute barred. Now, you and I have been explaining this to our clients for years and years and years, so I'm glad to see the government has caught up with us. Now, the third thing that has happened is, you've probably heard of this, Ted, COVID. I don't know if I'm pronouncing that right or not. Mm-hmm. And lockdowns and people losing their job and so on. So here we are, January of 2022. We're getting close to that 2-year mark because, of course, the lockdown started in March of 2020. So do you think creditors are going to start suing because they have to do it before their 2-year period runs out?
Well, it's not as easy as just saying, are they going to start suing? Have they got the ability right now to even start suing? I mean, set aside the optics. The world's in a semi-shutdown and you're trying to sue people for an old debt. That's got to look really bad. Just getting something through the courts right now is damn difficult. They're doing things virtually. They're moving fairly slowly and they're not doing a heavy workload. So I have my doubts whether or not anybody's going to try and do anything.
Yeah, I mean, we have seen people are getting sued. It's not like nobody's been sued.
Yeah, don't take this from me saying that nobody's getting sued because that would be false.
Yeah,
but
and there
far
are
fewer than there used to be.
And that's because of the difficulties with the court, as you said, but also because why am I going to spend money on lawyers to sue someone if the person isn't working?
Right.
Kind of wasting my money there. But there are certainly, and I can think of a couple of institutions who I won't mention on this show that, yeah, they're still suing lots of people.
Right.
So big banks, big credit card companies, that sort of thing. So I agree with you. They have the ability to do it. Whether they're going to really ramp it up or not, who knows? Now, you and I did our year-end predictions show, which aired on January 1st. And so here we are, like 10 days later. I believe on that show, I predicted that, oh, yes, I think there's going to be a lot more legal action in the months to come. And here we are 10 days after that, and we're already backtracking on our predictions. So that's, of course, at that point, we weren't in the level of lockdowns that we're in now.
Right. That's true. And I'm not certain how long this lockdown will be in place anyway. So, I mean, it could very well be that 4 weeks from now, things are normalizing again the way they were in the fall, and the lawsuit activity will pick up.
Yeah, we just
don't know.
If I had to guess, I would agree that, yeah, by February or March, things will be a lot different than they are now, but who knows? We're gonna see. So I want to go through 3 examples to illustrate what we're talking about here. But before we do, let's fire off some rapid questions here just to make sure that we're all on the same page here. So question number 1, what does statute barred mean?
Well, so it means that based on the current state of the law, someone cannot pursue you for that debt. So the law says, can't come after me for this debt anymore. It's too old.
There you go. So, and in most cases, it's the 2-year rule that we just talked about.
Right.
So, and again, you kind of already addressed this, but how is the 2 years calculated then?
Yeah. So the most obvious way is since your last payment. The second way is the last time you confirmed, last time you said, yeah, I owe you the money. And most lawyers are saying that it has to be in writing. I don't think that it does, but anyway.
Yeah. And again, it all depends what the judge says when you go to court, but
that's right.
But yes, if you've got a debt that you haven't made any payments on in 5 years and haven't talked to anybody, then it's pretty much a statute barred debt.
Right.
Now, when I refer to debts, I'm talking about credit cards, bank loans, payday loans, that sort of thing. Does the Limitations Act apply to Canada Revenue Agency and things like tax debts?
It does not.
No, the answer is no.
Doesn't apply to any government debts. You know, it's interesting. It doesn't apply to us either.
What do you mean?
So if you get a conditional order of discharge and you don't pay it for 2 years, you still owe the money.
Yeah.
So, because it's a court-imposed payment.
Right. So a court-imposed payment, in other words, somebody sues you and gets a judgment, then again, we're oversimplifying, but that judgment's there forever.
Yeah, they can. There's a statute of limitations on how long they can take those actions too, but it's a lot longer than 2 years.
Yeah, and again, you can read the Limitations Act. I'll put links in the show notes
Right.
for people who want to do all the research. But yeah, and I guess that's a very key point here. If you've got a credit card that you haven't paid for a few years, it's statute barred. But if that credit card company sued you and got a judgment, and even if they got that judgment 3 years ago, they can still enforce the judgment today.
That's right.
That's a key.
Yes. So the Limitations Act stops people from obtaining judgments. Once a judgment is in place, the Limitations Act doesn't apply.
Very key point. So, okay, Canada Revenue Agency, there is no limitations period. So if you owe taxes from 5 years ago, too bad, they can still come after you.
Same thing for EI and that sort of debt too, government services.
Yeah, if you had an overpayment of employment insurance, things like that.
Student loans.
Student loans is another good example. Again, if it's a government guaranteed student loan, then they've got way more rights than a typical creditor would be.
Right.
And at some point later this year, we will do another show about, well, what happens if I owed money on CERB and have to pay it back?
Yeah.
And again, we've addressed that before. Yeah, if the government says it's a debt, then it's a debt. You have to pay it back unless obviously you go through a bankruptcy or consumer proposal.
Right.
So court fines, what's the deal on them?
Yeah, fines have no limitations on them at all. So
limitations period, does it apply to spousal support and child support?
it does not. The only way you can get those amounts changed is to go back to family court and have a judge vary the order.
And that's what we're talking about, arrears here. So if you are in arrears for X number of dollars on your spousal or child support, doesn't matter how long you've been in arrears for, it's still a debt. You can't get out of it by saying, oh, I didn't pay it for 2
Right.
years.
It doesn't matter that the kid is now 25 and has two of their own kids. If you owed the money when they were a minor, then you still owe the money.
You still owe the money. So the limitations period applies for typical unsecured debts like bank debt. It does not apply for government and
Call it commercial debts.
Yeah, it applies to commercial debts, doesn't apply to the other stuff. Now,
Right.
the thing that confuses a lot of people with this is they call me up and I explain to them about the 2 years and they go, yeah, but it's on my credit report for longer than that.
Right.
So I want to be clear here. We are talking about the limitations period, which is the period in which a commercial creditor can sue you, but a debt remains on your credit report for generally 6 years from the last activity date, and then it's automatically purged.
Well, and the last activity date is the last activity reported by the lender. So it doesn't necessarily, I mean, you could stop paying. They've been reporting for 2 years. And every month they update it somehow because they're applying interest or whatever else, 6 years from that date.
Yeah. And typically a lender is going to, post the last activity date. I mean, they're relatively accurate on that.
A bank or somebody,
Legit.
So I'm going to say reputable.
Reputable. Yeah, there you go.
Edit that out if you want. Some of the less reputable lenders deliberately will put something in, to extend that period of time. So they'll post something 2 years after the fact and now the 6 years starts again, just to be jerks.
Well, and what they may also do is say, hey, look, you haven't paid for a couple of years. As a show of good faith, I would like you to make a $10 payment.
Right.
And you go, okay, fine, $10. Here you go. Well, guess what? You just started the 2-year limitation period again.
Right.
So beware of those tricks. And I think if you're ever confused about any of that, then that's what we're here for. Obviously, you go to Hoyes.com and fire us a message. Okay, now.
When in doubt, don't pay them.
Yeah. Do some research, figure it out first, talk to a licensed insolvency trustee, talk to a lawyer, whatever. Okay. I want to throw 3 case studies at you. And I want you to tell me what you would advise the person if they had walked into your office while we were recording this podcast. So first person, the first person has a cell phone bill from 4 years ago. Okay. All of their other debts are current. They get a call from ABC collection agency saying, hey, if you don't pay, we're going to take you to court. So what would your advice to that person be?
Well, so the first thing, are they going to take you to court? It's unlikely. I mean, very few creditors sue, very few cell phone companies sue. So I mean, it's a threat and it's valid. It's just not likely. So don't put too much weight in it. If they do take you to court, that's when the Limitation Act kicks in. The whole purpose of the Limitation Act is to give you a defense in court that says, wait a minute, it's more than 2 years old. I didn't think I owed this money anymore.
Right. And you raised the other key point that I don't think we emphasized enough here. It's the Limitation Act doesn't say nobody can sue you.
Right.
It says if they do sue you, you have to show up in court, file a defense and say, hey, judge, it's been more than 2 years. And then at that point, assuming the judge understands the law and you can prove it, then it gets thrown out.
And so what happens to most people is they just ignore the damn lawsuit. And it doesn't matter then how long you've owed the money because the judge is going to give them a default judgment. They're not even going to look at it. They're just going to rubber stamp it and say, well, you didn't show up in court, so I guess you agree.
Yeah, the judge has no way of knowing how old the debt is.
Right.
Because it's not like the creditor is going to tell them. Mm-hmm. So if you do get sued, even if it's for an old debt, you still have to show up and say, hey, here's the deal. It's past the limitation. Is that one of your creditors calling you your debt?
It's actually somebody trying to get a charitable donation.
Oh, okay, that's even better then. You can call them back. So yes, you have to actually file a defense. Now, in this particular case, if the guy does nothing, the debt is 4 years old, it will be purged from his credit report 2 years from now. Because it's 6 years, probably, assuming everything's on the up and up. Yep. However, if he makes a payment to them and pays it off in full, then that late payment and then the subsequent payment is on his credit report for 6 years.
Correct.
So I would argue you're actually worse off paying a very old debt than not paying it because it's more negative on your credit report.
In this case, and it often is the case, particularly with collection agencies, not doing anything probably makes the most sense.
Yeah, unless again they decide to take
get a
it to
court.
court and sue you, and then you got to do something. Okay, so that was case study number one, a very old debt, and that was the only debt the person had. Now,
Right.
case study number two, another person hasn't made any payments on their credit card for 18 months. Okay, so they have a credit card, they have not made any payments on it for 18 months. So what then should they do in that particular case?
They should take a hammer to their cell phone.
There you go.
All right. Well, so if you got the money, you should pay the bill. I mean, that just makes sense, right? If you have an obligation to pay and you're able to pay, people expect you to pay. If you don't have the money, but you will, then you could enter into a payment plan or some kind of arrangement with the company that you owe. So you call the credit card company and say, okay, I'll pay off the balance over the next 6 months. Most of them are receptive to that sort of thing. They'll keep charging you interest, but it'll clear up your credit and you can get it done. You could just wait it out, right? It's been 18 months now, give it another 6 months and 24 months, then you have the defense. Should they sue you? Well, it's been more than 24 months. It's statute barred. And, usually if you've got one credit card that's overdue, you've got other debts that are overdue as well. So it might make sense to actually call somebody like you or me, a licensed insolvency trustee, to talk about options, because most folks don't just have one debt that's overdue. It's usually a bunch of stuff.
Yeah, and I think you made the key point there that if you can pay your debts, you should.
Yeah, I mean, that's our whole system is based on you get credit because you're going to pay it later. Well, at some point, somebody's got to pay it later.
Right. And we're certainly not saying, oh, well, anybody who has debts, just go bankrupt, do a proposal. No, we're not saying that. Obviously, that has negative ramifications for things like credit reports and ability to borrow in the future and whatnot. So if you can pay it, pay it. And if you can pay it over a reasonable time, I'm not saying, okay, it's going to take me 15 years to pay off my credit card, I should do it. Well, again, I think that's where you'd want to talk to us. But what we are addressing is the person who has debt that they just cannot pay. There is no reasonable pathway to see them being able to do it. And that's when you need to reach out for help. So case study number 3, what do you do in the hybrid case where you've got someone who's got some old debts and they've got some new debts? So, okay, I could ignore the old debts because maybe they'll go away, but I've also got some new debts. How do I make the decision on what my next step is there?
Yeah, this case study kind of grows out of the old one. You've already got old debts, and now you've got new debts. Now, debts don't just go away. You got to deal with the problem somehow. So I think I'll start by saying, well, maybe contact a licensed insolvency trustee, somebody like you, somebody like me, somebody that's going to take a look at your overall situation and give you options on how to deal with this stuff.
It sounds like a commercial we're doing here today.
It does sound, and we don't usually do that.
No, but call now.
But you led me down the path, didn't you?
That's right.
You knew I was distracted.
That's right, exactly.
My telephone.
That's right. Yeah, it's always hard when we're not in our sealed studio to do these things. Now, I totally agree with what you said. The issue is, okay, so I've got a couple of 3-year-old debts and a couple of new ones. There's no way I can pay even the new ones. So I go ahead, I file a proposal, I file a bankruptcy. But the claim for those old debts is not a provable claim in my bankruptcy or proposal. So if that old cell phone company in our example files a claim, as the trustee, you or I are going to say, oh, sorry, we can't take it, which means now the creditor is going to keep bugging me.
Yeah. So from a legal standpoint, that's what things are supposed to mean now. That's what the director from the OSB in December told us to do. Find out if it's statute barred. If it's statute barred, you can't prove it. It's not a provable claim, which means it can't be included in the bankruptcy proposal. The practical thing that we've been doing, and we've been doing this all along, is you owe somebody money, list it as one of your debts, and then we'll deal with it. Because most of these guys, the credit reporting agencies in Canada are screwed up now anyway, because lots of companies are buying old debts, things that are statute barred, and they're sending out notices saying, hey, we've got this old cell phone debt 10 years ago. You didn't pay it. You got to pay us now. And they're reporting that on your credit report as a new debt because they just purchased it. They're playing all sorts of tricks and games that are screwing around with people's credit reports. And so I don't think the OSB did anyone any favors by making that change to the directive in December. I think they've got to think it through further. And the thing that needs to be done is it's a claim that can be listed and dealt with. And if it is on your credit report at the end of a bankruptcy, it should be purged as part of the bankruptcy's purging. So they may not be entitled to money from the bankruptcy or the proposal, but they should definitely be cleaned up by the bankruptcy and the proposal. But the OSB hasn't thought that through yet.
Yeah. And, far be it for me to come to the defense of the regulator, but this is really the court case that has spurred this on, the Eaton case, as opposed to the OSB taking the direct action. However, I think your point is a valid one. Our approach is you got debts, we're going to list them. And at least that way, all the creditors get notified. And in the vast majority of cases, they look at it and they go, okay, the guy's bankrupt. Even though maybe we can play games, why would we bother? We know he doesn't have any money anyways. I had a chat just before Christmas with a large debt buying organization, and I asked them about this. And they said, yep, we're aware of the rules. We're not pursuing, the old stuff because we realize there's really not that much money in it. So it's not that we're nice guys and benevolent and anything. It's just there really isn't a whole lot of a point to doing it. So again, if there are issues with this, reach out to us and we will walk you through it. So, okay, I think we've kind of explained that. Any final comments you would like to make on any of those points there, Ted?
Yeah. So the point we really needed to emphasize was the Limitations Act is a defense in court. It's not an automatic provision of the law. So if somebody sues you and it's been more than 2 years, so the debt is statute barred, you have to actively tell the judge that it's statute barred. If you don't, the judge will just give them a default judgment and they'll come after you for the money. And it's a lot harder after a judgment has been issued to have it varied than it is to stop it in the first place.
Yeah, almost impossible. It's not impossible, but you're right.
It's
very
expensive.
difficult. Yeah. So you're going to go to the judge and say, oh, judge, I didn't show up the first time to tell you this thing. Now here I am. I want you to undo what you did. And of course, you're not going to get the same judge. So now you've got a different judge who's going to overrule another. Yeah, it's just, and a lot of the time we're talking about small claims court actions, things anyway. So unlikely they're going to want to pursue it. So
the single most important aspect to all of this is, if you've got debts, old ones, new ones, whatever, you got to deal with them somehow. COVID has been pretty good at having people hunker down and kind of, you get your foxhole and you hide and you wait for this thing to end. At some point, you got to deal with your problems, and debts are one of those problems that have to be dealt with.
Yeah, you're right. They don't go away on their own.
Right.
So, there's no better time than the present to at least understand what the options are. So excellent. Well, thank you very much, Ted. So the answer to the question, do I have to pay my old debts, is, well, if it's a credit card, an unsecured bank loan, payday loan, and if you haven't made any payments on it in over 2 years and you live in Ontario, and if they haven't sued you yet, then the lender likely can't sue you for it. So likely they can't collect, so you could just decide not to pay it. Simple as that. However, debts are reported on your credit bureau for 6 years. So if you don't pay it, even though they may not be able to collect it, it'll trash your credit score and affect your ability to borrow in the future. So my advice, Ted's advice is, we already said it, if you can pay your debts, pay them. If you can't pay them, then don't, but realize it'll impact your ability to borrow in the future. And of course, if you have a lot of debts that you can't pay, talk to a lawyer, talk to a licensed insolvency trustee. When you call our professionals here at Hoyes and Michalos, the consultation is free. And why is that, Ted? Why are our consultations free?
Why are they free?
Yeah.
Well, because half the people that call us don't really need our services. They just need to be pointed in the right direction.
Well, and it's the law. We're not allowed to charge you an upfront fee. So if anybody is charging you
that,
it's the law. It's quite clearly the law. And so you and I have done many shows about these people who are charging a lot of fees for nothing.
You're just trying to get me going now, right?
I am. I know we've had a rough start to today. So the point is, we can quite easily start with a quick phone call, or what we're doing right now over Zoom. Right. We do a lot of meetings by Zoom now. So give us a call. We'll explain your option. Old debt may be statute barred, but it doesn't just go away. So reaching out for help is the prudent strategy. Right. That's our show for today. I will put links to everything we talked about in the show notes on YouTube, including links to the Limitations Act, if you want to read it for yourself. If you are watching on YouTube, please like, subscribe, send it to all your friends, families, acquaintances, everybody you know. And that way we get the word out. Until next week, and I don't know where Ted and I will be next week, but tune in to find out.
Won't be here. There's so many people coming in and my phone's ringing all the time. What the hell is this?
We'll be somewhere. Until next week, for Ted Michalos, I'm Doug Hoyes. That was Debt Free in 30. And look at that.